Vision Corporation versus Brew. I'm sure someone could correct me if I'm pronouncing the name.
Morning, may it please the court. Corey Chandler on behalf of the appellants. Your Honor, the appellant in this case is seeking an order reversing the trial court's decision granting the derivative plaintiff's motion for summary judgment. In similar fashion, an order reversing the motion to deny the rehearing. This is a fairly simple case involving a loan obligation between Fission and MGA. Admittedly, there was an $82,000 loan in October of 2018. That loan was not repaid until March of 2021, mid-course in the litigation. Sometime after that, I'm going to say free, I think this. If I'm saying free, it's through, yeah, I think so. Moved for summary judgment, and in opposition to summary judgment, Fission filed an affidavit from William Gerhauser, essentially opposing the affidavit, saying in March of 2021, as repayment of this loan that was between Fission and MGA. Fission transferred approximately 3.2 million shares of stock.
You may or may not have been listening to Rick's argument about silence, but and given the silence regarding whether there was some there's an allowance that was to be paid in stock. Was there any ambiguity that would allow that affidavit to be utilized to construe the document as relevant? It said funds.
Oh, right. So yeah.
It said dollars.
Yeah.
So
So
the dollar sign and it said funds. Right. Is there any ambiguity about what would satisfy the debt, whether it's in kind, livestock,
yeah,
chickens,
I think
stock?
yeah.
Where's the ambiguity that would allow that affidavit?
Well, I think in the total of the circumstances, because one, you see that the parties anticipated there would be bridge financing. If that didn't happen, I do believe that this language that follows, that funds are
bridge
due.
finance.
I'm sorry.
What happens? What would happen if the bridge financing?
I think basically the loan obligation would be transferred from Fission to another unrelated party.
In that scenario, what would be required? Who would ultimately pay it off, and in what would they pay it?
Well, I don't know, but I mean, ultimately either by Fission or on behalf of Fission, funds would be cash would be transferred, right? And so I understand where the court's going with this, but I do think there's 2 points to that. One, I think funds is sufficiently ambiguous that the parties could agree that rather than funds, you would do a stock equivalent on that.
The affidavit was submitted after the judge's order, is that correct?
No, sir. Well, there were 2 affidavits in the
Okay, I'm
case.
trying, because you mentioned affidavit, I'm trying to figure out which one to talk.
There was one affidavit submitted in support of the motion for summary judgment, and then a more comprehensive supplemental affidavit in support of the motion for rehearing.
Okay, so the only ground given by the trial court was the fact that the note, in his view, needed to be repaid in cash.
Right. He never addressed whether or not that was ambiguous or whether or not the parties could alter the terms of the contract and agree in lieu of cash. Could we actually accept Fission stock in exchange, which I don't think is necessarily unusual.
Was there any evidence other than that affidavit attached to the push for a rehearing? Was there any evidence of a relation or a refund amendment?
No, sir. That's it. Yeah.
Ms. Free is a 50% holder of the LLC.
It's my understanding. Yes, Judge.
I take it since no one's argued that she's a sufficient derivative plaintiff on behalf of the LLC.
I believe so, yes, Judge. I think that was sort of argued originally from a motion to this standpoint, but yes, we haven't challenged that at this point.
Okay.
Um,
And would the other 50% holder have been authorized to enter another agreement to substitute restricted stock or cash?
that decision was not addressed at the trial court. Now, that's sort of this periphery issue that's been alleged by Maria Free, sort of like, oh, Mr. Gerhauser's entering into these interested transactions, even though that was contemplated.
But doesn't your argument rely on the specific answer to Judge LaRosa's question?
I think it does. Yeah, I think it relies on the fact that he does require that, although not necessarily that issue be addressed in a derivative action, because
But I'm saying that the authority of Mr. G, like,
yeah,
no.
I understood.
Yeah, I just scratch my head because there are many things I wonder, why aren't they talking about them, but it's your case, so.
Right. Well, I don't think that was addressed. One, I mean, I think the appellee sort of touches on it in his appellee answer brief. It sort of is like, well, it's questionable whether Mr. Gerhauser had the authority to enter under this contract. Now, there is term,
Which contract?
well, I didn't mean enter into the contract, alter the terms of the contract.
I'm asking you, but it seems like you sort of brought that burden upon yourself a minute ago when you made the argument that that there's nothing that stops the party or the party, the corporate entity and the borrower from renegotiating terms. But my question, Judge Rose's question was, I think I heard correctly, is Mr. Gerhauser, about the shareholder, have the authority to unilaterally do that?
Well, considering that he had the authority to enter into the contract in
Okay.
the first place, I think the answer to that question is yeah.
Okay.
Yeah.
That's before us, it's just,
Yeah,
we've got, in the first instance, it seems, strikes me that the trial court just looked at the language of the note, and it talks about funds, talks about dollar amount, it talks about an alternative being bridge financing. So there's no other alternative except those funds or proceeds of bridge finance.
other than the agreement between Fission and MGA to alter the terms of the contract to accept stock in lieu of
Restricted stock.
cash. Well, again, I'm
I
sorry.
understand
Yeah.
your argument is the restriction period ends at some point, right?
I think that is one argument, but that again is probably a material fact that was not adequately addressed by the trial court.
Well, all the, it strikes me, forgive me, all the things that are in the affidavit of the hearing seems to me bolsters Ms. Free's case. I mean, if you give restricted stock, the other side is not getting the benefit of the bargain. They cannot do anything with it for the term of the restricted period.
Well, and I'll agree with that, although the restricted stock argument rose for the first time at the hearing on the motion for summary judgment. So we addressed that in a motion for rehearing. And I do think that even though this necessarily has this time period where it's restricted, right? And I don't think that's certain from the record. I mean, that issue has not been adequately addressed either by brief or by the trial. So you can say it's restricted, and then maybe there's some admissions to that effect in the affidavit attached to the motion for rehearing. But even if that period is 6 months, right? Because let's assume that stock price doubled in price. You can't really say, I didn't get the benefit of that bargain, right? We don't know what the future is. I'm sorry, or it tanks, right? But either way, that's a risk that obviously MGA was engaged to go out into the,
Strikes me that the affidavits that are presented create a murky background. Whereas the trial judge just sort of looks at the note, finds it ambiguous and say, there's been a default, right? He didn't pay cash, he didn't pay proceeds from a bridge loan. Or he's over.
except that the parties agreed in the affidavit for motion for rehearing that MGA would accept stock in lieu of that.
But all that stuff could have been brought out at the hearing. It seems to me that subsequent hearing affidavit is just rehashing things that could have been brought out initially, because they all had previously occurred, right?
Well, except that I was confronted with that argument, as I recall, at the hearing. In other words, that wasn't briefed to the trial court ahead of plaintiff's hearing on motion for summary judgment. So I had to address it because, you know, for lack of better words, it's an argument that I'm hearing for the first time in oral argument from plaintiff's motion for summary judgment, as I recall.
Well, you got, it seems to me, if there's a question that seems easily phrased, whether or not it was a default under the note, we would have been ready to bring forward all the details about other agreements to take.
Well, I think we did, and I mean, we at least raised a genuine issue to material fact for the first affidavit, saying, look, we transferred stock as, now, even that language is sort of,
There's even your documents and your affidavit creates some confusion as to whether indeed the stock was ever tendered.
right, well,
And you can't use something that's a problem for you to create an issue of fact.
well, I think the first affidavit says, although it doesn't say it was intended as repayment, because if you look at those cases where you have a rehearing and that there are supplemental affidavits that sort of correct technical defects in the motion for summary judgment, that sort of is what occurred in this case, because really the first affidavit says I transferred stock. Now, that was in lieu of, and the circumstances and a justifiable inference from, even though that may be defective at that time, the circumstances, the justifiable inference, and the light most favorable to the non-moving party indicates that obviously there's no other reason for that transfer of stock other than as payment for the loan.
So we're looking at a simple legal issue that the note allowed for an alternative payment.
Or did the parties agree subsequently to accept stock in lieu of payment? Yeah. And I think those issues are, that sort of genuine issue of the material fact is raised by the affidavit in opposition to plaintiff's motion for summary judgment, and the affidavit attached to the motion for rehearing.
You want some rebuttal time?
Yeah, I'll say some. A few minutes on rebuttal.
5 minutes rebuttal.
Okay. Great. Thank you.
Thank you.
Morning.
Good morning.
May it please the court. My name is Steve Cohen. I'm from Bajo Cohen, Atlanta, in Tampa. I represent Marina Free, who is the plaintiff in this action, the appellee. As you know, she brought this derivative action on behalf of MGA Holdings LLC to recover monies that were loaned by MGA to Fission. Couple of questions that were asked to my colleague, Mr. Chandler, that I would like to address this concept that there was some sort of a agreement after the loan went into default to that it could be converted. That's an innovation or an amendment or a modification. That's not been pled. You will not see that in the answer and the affirmative defenses, amended answer and affirmative defenses that were filed, I believe, on June 8th of 2021. I think that issue's been waived.
If that affidavit that was attached to the motion for hearing and shown up in some judgment evidence prior to the hearing and argued at the hearing, you would say it was already waived because
It's not
in
been
their
pled.
answer or their affirmative defense, they didn't say, hey, this agreement is modified.
I think it has to be pled. Yes, modification. I think it's the affirmative defense.
Well, let me ask you, did it come up in discovery? Was there any deposition testimony in which Mr. Garrett, or maybe I'm mispronouncing his name, said, oh, no, I agree with the borrower. Yeah, I agree with the borrower, at the time we amended the agreement. Did that even come up in discovery? No, it wasn't in it, at summary judgment evidence at all. Whether it's waived or not, by virtue of not being an answer, was it in the summary judgment evidence at all?
So there is a document that Mr. Gearhauser signed on behalf of MGA. It's not signed on behalf of Vision by Mr. Gearhauser. He would have been on both sides of the transaction. And it's called they call it a conversion notice. That would be the only document I'm aware of that came up at summary judgment. Your Honor, there were no depositions taken prior to our filing our motion. Our motion was based on the plain and unambiguous language of the promissory note, which no one has taken issue that note, even though it's unsigned, and Judge Parponte raised this issue at the hearing. Even the note is not signed, that is not the note that memorializes the loan. And as you pointed out, that note talks in terms of repayment in dollars and funds, which is cash, not stock. And if you were to go on the internet and look at the website that's cited by counsel in the initial brief as to what a convertible debenture looks like, what you'll see is it usually says conversion, and it has a process for how to convert the note. None of that exists here. This is a very simple, and also it's usually a longer term obligation. This was a 1 month payment term. So it was a quick turnaround. That's evident. And Judge Parponte, I think that he did rule that the note was clear and unambiguous. If you look at his holding in his written order, he said the promissory note attached to the parties' filings is not convertible. It is clear that payment is to be in cash. So he used the word clear as opposed to unambiguous, but I think you can fairly read his order, say the clear and unambiguous terms of the note require payment in cash. And
That does not include a possibility that the parties could very well have modified the terms of the note.
I agree with that, Your Honor. It does not preclude a subsequent modification, except for the fact that, number one, here, the parties did not, because Mr. Gearhauser, as the controlling person of a public corporation, and he is undoubtedly the control person inside of Fission, cannot enter into that kind of an agreement with MGA, where he is the president and a 50% member. And particularly here, more troubling than anything is for years, or at least several years, and through many 10Ks and 10Qs, Fission announced to the federal government and the world that that note was not convertible. And then suddenly he mystically and magically converts it. That's where the alternative argument comes in, that he didn't have the authority to do that. The contract is governed by Delaware law, that operating agreement of MGA. That's not disputed. The business judgment rule in Delaware, if you're on, applies unless you're on both sides of the transaction, in which case it becomes a conflict of interest transaction. And in which case you have to go to I think they call it the total fairness standard, where you have to have fair terms and fair price. And under Florida law, Florida has statute of the corporate statute, you would have to have the unbiased directors or shareholders make the decision. So that's where that argument comes up. Fair terms, fair price. Here, this concept that there was a March 2022 or 21 payment, okay, it's a disingenuous argument. At best, what they transferred was restricted stock, and in their answer brief at the reply brief at page 6, they tell you it's restricted stock, and they tell you what SEC Rule 144 means, which is you can't negotiate the stock. So how is that payment? That can't be payment. And it certainly doesn't render the contract ambiguous, because as this court pointed out in the case that we didn't cite, but it was under the old summary judgment rule, I think it's White versus Fort Myers. An absurd interpretation of the contract cannot create any ambiguity. If there's no other questions, we stand on our briefs. Then we request the court affirm Judge Porfonte's summary judgment.
Very well. Thank you, Mr. Cohen. Mr. Chandler?
Yes, Judge, I'll wrap it up quickly unless you have questions. So one thing that's interesting about your Hauser, Mr. G's authority in this particular case is that no one questioned whether or not Gerhauser had the authority to enter into the contract. In other words, there was nothing ever alleged or argued by Free that this contract was invalid or that Mr. Gerhauser
Which contract are you talking about?
well, this is the promissory note. Yes, I'm sorry, the promissory note. So it sort of goes along the lines of like, at this point, haven't you waived that argument that Mr. Gerhauser doesn't have that?
Well, he had
The authority.
It was assumed he has the authority to enter into the note. Back in the matter is the note is due.
Right, and he also has the authority to alter the terms of the agreement.
But you have to come up with some judgment evidence of that.
Well, and I did, in terms of, well, remember, his authority necessarily wasn't really challenged. I mean,
What I'm saying, well, my understanding is you have two arguments. Or, there's any alternative. One is that this note allowed for some sort of in-kind repayment,
right.
right? And the trial court disagreed with you on that. And then the other argument is that there was some sort of negotiated amendment to the agreement between the lender, MGA, and the water. And for that argument, you can't just say, well, maybe there was one, right? At summary judgment, especially in the standard, you have to show that there was.
Right.
What's the summary judgment evidence that shows that there was such an agreement?
Yeah, admittedly, I don't think that was addressed until my motion for rehearing.
Okay.
I do think that it's pretty clear in the affidavit where Gerhauser swears the parties intended that the $3.5 million shares of stock was intended as repayment for the promissory note. And that calls into question, if that's a technical defect, then I think the trial court, and under that sort of Willis case, I know that I cite the holding in my brief incorrectly in Willis, but if you take Hall and Willis together, it sort of suggests that the trial court has broad discretion to grant a motion for rehearing unless you've actually, supplemented properly affidavits that create a genuine issue of material fact and not raising it for the first time on rehearing, which is what happened in this case. In other words, a supplemental affidavit, as opposed to an affidavit raising a genuine issue for the first time on rehearing. In that case, the Hall case, even though it's an old decision from 1966, it says the trial court's discretion narrows in that particular circumstance. And when you have a affidavit from Gerhauser saying, look, this in effect was a modification intended to satisfy the outstanding obligation on that loan, that's sufficient to create a genuine issue of material fact. Okay.
Very good. Thank you, Mr. Chandler.
Thank you.
Thank you both. Our last case this morning is McKenna versus Snyder.